is the recent proposed amendment to the FCRA really tightening the noose on the churches operating in India, or is it simply a restriction being imposed on foreign funding? After a recent debate regarding the FCRA bill and its effect on the religious institutions, specifically churches, after the matter began to be discussed in the US, this particular amendment itself has become a center of global debate. So, what exactly this amendment proposes? Who will be impacted and affected by these amendments, and what is going to be its impact on India-US ties? Let us try to decode it in a simple language. To give you background of this entire topic, US Republican Congressman Riley Moore has criticized the recent proposed FCRA amendment bill that is going to be discussed in Parliament few days from now. It has impacted and affected the Indo-US relationship to some extent, and it also has brought controversy as it is seen as anti-church bill, anti-church amendment in nature. The reason is because it talks about the management of asset which is being funded by the foreign contribution or foreign fund as such. Now, the biggest question that comes into mind is what is FCRA? Now, FCRA stands for Foreign Contribution Regulation Act. In simple terms, this particular act regulates foreign donations and grants that is received by the NGOs, associations and even individuals in India. It requires to have a FCRA certificate, and that has to be renewed by every organization which has the certificate after every 5 years as such. This serves as oversight by government to ensure that foreign funding that is received by institutions and organizations in India are only used for constructive and creative purposes, not for funding the anti-state or anti-India forces as such. Now, the objective of the recent amendment is to further tighten and supervise the foreign funds received by the organization and to manage assets by designated authorities if the licenses or the FCRA license of these organizations have not been renewed after 5 years as such. It increases overall the compliance burden as far as the FCRA is concerned on all the institutions which are getting foreign fund to some extent. Registration framework has been established, and government has defended this amendment as a way of increasing and ensuring public accountability as far as the foreign funds flowing into India is concerned. Now, the question is that when FCRA certificate that any organization NGO has would cease to exist or would cease to be valid in nature. So, there are several conditions. First, we have seen that every FCRA certificate has a life of 5 years. So, at the end of 5 years, it automatically expires. Second, if before 5 years or before the expiry of certificate, if it is not renewed by the stakeholder, then also it will automatically expire or will cease to be a valid document. Or even if an organization has submitted a renewal application, but the government rejects it based on any of the ground, then it will also cease to exist. So, no renewal application, if no one has submitted a renewal application, then obviously it will cease to exist, and that will lead to loss of registration. Once FCRA registration is lost, that particular organization or association would not be able to receive any kind of foreign contribution either in the form of donations or in the form of charity as such. If it indeed receives it, it would be considered and deemed as an illegal act as such. Now, before understanding in more detail about the changes and how it is going to impact religious institution, I would want to bring attention to the fact that Legacy as Academy is going to soon commence batches on 7th of September and 3rd of November. That will be regular weekday batch every day between Monday to Friday. You will have lessons from 10 to 5 p.m. Weekend batches is for students who are preparing for examination along with the full-time studies or jobs. That is going to commence on 8th of August, 10th of October and 12th of December. Now, in this particular batch, we ensure comprehensive coverage of all the GS paper, both from prelims and mains perspective. We also have included one-to-one mentorship and doubt solving session so that students can get assistance and help not only in the classroom but even outside the classroom, not only related to the subjects of the UPSC and the guidelines about it, but also how to remain on track as far as this preparation is concerned. Also, to ensure that there is a proper discussions and interaction in the classroom, we ensure that maximum 40 students are admitted per batch. Plus, to encourage integrated participation, integrated preparation of the examination, from beginning itself we inculcate practices of daily mains and answer writing. Test series also are part of the course programs and features so that students can evaluate themselves and understand their strengths and weaknesses. Apart from general studies, we also know that how important role you optionals paper play as far as deciding rank or even getting your name in the PDF is concerned. So, for that we have psychology, PSI, anthropology and sociology, four most opted optional as far as the UPSC civil service examination is concerned. The course is going to commence on 17th of August every day between 8 to 10 am as such. Now, if you want to know more detail and more detail about course program and feature, you can call to the number being displayed here. You can also scroll through our website and can download our Legacy IAS app that will help you a great deal in your UPSC journey. Now, coming back to the topic, the bill also specifies that a designated authorities would be constituted which will take charge of the assets that will lapse if the FCRA registration is not renewed as such. So, this would take charge of all the foreign funded property. Provisional vesting and permanent vesting. Two type of vesting has been explained here. Provisional vesting in the case if the organization obtains a fresh certificate or its registration is renewed or restored. In that case, the property that is vested in this DA, that is designated authority, would again be transferred back to the associations or organization. Other is if that renewal of registration or restoration of registration is not done. In that case, the asset would permanently be managed by the DA and then it would be disposed in accordance with the provisions of law. Now, once asset is permanently acquired by DA, in that case, how it will be disposed? So, the amendment bill says that it would be disposed for the public purposes, so the general well-being of public. It can be transferred to the central or state government, and the fund that the DA can organize or DA can generate from the selling of this property, for example, would then be vested in the consolidated fund of India. This is how asset disposal would be done as such. Now, the question and the controversy largely is related to its application on the religious institution, more specifically churches. Why? Because as we have seen, the US Congressman Riley Moore has criticized the bill as an anti-Christian bill. It is going to adversely impact the Indo-US relation. That is what he has claimed. So, it is true that churches are covered under this bill. But in this particular amendment bill, churches are not only religious institution that is being targeted. All religions are being covered here. So, whether it is church, whether it is the, we can call as mosque, anything that is getting foreign funds, they would be covered. Not only the religious institutions, even other social institutions such as hospitals, schools or libraries, anything that is funded by foreign contribution, foreign donations, they will see the application of this particular amendment law if it passes through parliament. Now, important thing is that this law also provides protection to the religious character of the institution as such. So, if for example, if a permanently vested asset is wholly or partly a place of worship, for example, suppose a church was constructed by receiving foreign fund and now due to the non-renewable or cancellation of FCRA licenses, that church would go with the designated authority as we have discussed before. Now, designated authority would not then destroy the church or dismantle the church or for it matter any of the religious institution. They would ensure that the character of or religious character of this particular place of worship is preserved. It will keep operating like a church, but it will not be any more controlled by the organization that was controlling it. Now, the issue that is raised here is something that we can understand by taking a real example. Suppose that several years back, foreign contribution was used to create an asset. It can be hospital, it can be library, anything you can keep in mind. Now, later what happened? Later suppose the organization responsible for its management stopped receiving any foreign money and they have shifted entirely to domestic funding. That means now in present time, the entire operation of this institution or this asset is by domestic funding only. In that case, FCRA would have been issued in the early cases because it was created as from the foreign contribution. If the FCRA now is not renewed, even though no foreign contribution is being received by this particular asset, the foreign funded asset could still vest with the designated authority. This is the most contentious provision over which concern and criticism has been raised. Apart from that, also it says in the discussion that, for example, if authority or organization has appealed for renewal of its FCRA license, but government due to certain reason denied that renewal, in that case there is no specific appeal mechanism. These organizations cannot go to a particular this appellate tribunal or something to appeal against the decision of government. Also, because here, as you have seen, the issue is being raised in the US political circle, that would cause diplomatic concern. It already has caused diplomatic concern because now not only Riley Moore but many other Republican congressmen has begun to raise voices against this bill as such. Overall, the discussion to some extent is now related to transparency versus regulation as such. Now, how the proposed asset management framework would affect FCRA regulated organization? This is the million-dollar question that is being asked by the critics and also by the opposition parties. So, we have to wait for 12th of August because that's when the discussion is going to be held in the parliament. as far as the FCRA bill is concerned. In those discussion, you might see more this detail coming out and more clarity about how government is going to apply this, and to what extent government has provided protection to the organizations so that they do not suffer even if they are not at fault. So that's all about this particular issue. I hope you understood what is the reason behind the FCRA amendment and what are the major provisions and the grounds of criticism. So if you like the video, please hit the like button, share it with fellow aspirants, as well as subscribe to the channel for more such helpful content. Thank you very much.